Okay, good afternoon everyone, and welcome to the second seminar of Wednesday, the 15th of July. This evening we are with Henry Hathaway, who's going to be talking to us about, or an update really on his regular chat on COVID-19 versus your construction contract. So as more and more sites are returning to work and more and more things are starting to move, Henry's giving us an update on the latest from the construction world. So as always, questions in the Q&A box please, and Henry will endeavour to answer as many as possible at the end. In the meantime, I will hand over to Mr. Hathaway. Henry, the floor is yours.
Hi, good evening everybody. Thanks very much for joining. I think that one of the different points that have been raised subsequently over the last number of weeks always pertain to the future in respect of what it is to be expected of in the industry now that these uncertain times. Certainly I joined in a webinar yesterday with quite a number of younger individuals within the construction industry, and to give an insight, etc., how COVID has actually affected younger people, their careers, and what of the expectations. And we were delighted, in fact, to have Sir Vivian Ramsey, former judge, in attendance as well, obviously, as well as being the former head of chambers in Keating for quite a number of years. And he's very distinguished in that point. But overreaching for a lot of the activity of what a lot of the different points that was discussed, of course, was what is the effects of what is going to and has happened, and of course is the lasting events of what is actually occurring. So broadly speaking, in terms of what the different cases have been to date, this really is just to summarize. In the first instance, I'll talk a little bit about Bresco, the changes, and obviously the route in terms of what's actually occurring within the legal sense. A little bit of an introduction into the Corporate Insolvency and Governance Act 2020. I was just about to say bill, but of course it has had royal assent. What the effects of those are, and of course what are the different points in relation to what measures the government have actually brought in in terms of cash flow, insolvency, and the fears within that. Moving on towards that as well, of course, as I mentioned, Bresco, what effect that would have, what current trends are in terms of adjudication, enforcement, what is actually occurring at this moment in time as well. Clearly as well, and moving on from that, is if we are talking about the detrimental points or the finality of difficulties in insolvency, then we'll actually talk about the current mode of contracts as well. The current trends or any of the cases coming before me, any of the instructions, and certainly the application of the key clauses, the difficulty surrounding to develop out what are in fact becoming quite complicated disruption claims, and how to best prepare for those as well. So back to the first point, of course, we're in very much the times of where most commentators, especially in banking and certainly in the areas of economics, are describing that the latter part of this year and certainly into the early part of next year. Of course, in property, we have the different instances of where we stand with stamp duty being released up until to zero, up to 500,000 on any of these inferences. Now, we have these commentaries coming from the government, which is build, 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 and that's on a very macro level, etc. And the key instances that will worry and are worrying most, especially small contractors, and certainly those with cash flow or points, will of course stand around the what insolvency, what are the measures. The Corporate Insolvency and Governance Act 2020 did get royal assent on 25th of June. And it brings out largely a number of different measures. So one of the first measures will be a moratorium. So what we have is a 20 business day moratorium, where an insolvency practitioner will actually be involved and will monitor the process. But effectively what it does is that it provides that moratorium, much the same. They were taking key principles from the existing rules and applying it in these points. So where an action may or may not cannot be taken, We also have different instances if there's a winding up petition, when it can be actually used, or how it can be actually brought about within, if the statutory demand has been presented within a certain timeline as well before now. All of these different instances where we're talking about restructuring as well, if there is a 75% of creditors, or indeed the approval of the court as well to allow for this. So what we're actually looking towards is those elements that are there to try and protect companies from the first instance of just instantaneously going into a voluntary liquidation process or a stage, and ultimately, or compulsory if it does get to that point. But ultimately, when we look at the measures that have also been taken, like wrongful trading. So wrongful trading, for those who have seen much about this before, would be trading while insolvent. And most people will ordinarily understand that trading while insolvent is obviously a breach. And there has been relaxation on that point. And of course, we will also understand the VAT deferment until next year. On one hand, these are all very, very useful measures to assist, to make sure that those in difficulty certainly don't arrive into a detrimental state of affairs. But also we need to understand that if the internal corporate governance is not surrounding or evident in those entities, these issues are ones that could amount, especially later on in the year or next year, especially when we consider the VAT. It's not a write-off by any shape or manner of means. It is simply a deferment. The key worry or key concern is that in a contracting environment or contracting business environment, with the type of deluge or tsunami of debt that's pushing up behind, that can lead to quite a difficult start of the next year potentially. So these measures instinctively don't replace that corporate governance or internal responsibility that companies have, or how they actually run through. And I know there's been a lot of commentary about bounce back loans on alternative financing and restructuring, etc., which of course all become part and parcel of it. But the real difficulty, of course, now in construction is who are we contracting with in that nature? How is their existing change? We've spoken previously about the external influence factors and the internal influence factors when it comes to insolvency and the threat. This is an industry that has faced really, really big issues. There was over 3,077 insolvencies in the construction sector alone by the end of the last quarter of the last financial year. That only relayed up until the end of March, 30th of March. So this is pre-COVID. So there is really a very large concern. The general feedback that we were having within many different entities is the fact that there is quite a lot of tendering going on, but whether or not projects are already starting to be shelved, or certainly, but there is also competition around pricing, reducing the pricing, reducing the margin, longer period, payment period, and certainly hotbeds of disputes, especially when we're talking about now that estimators have a much further larger difficulty in respect of actually how to price, taking in social distancing, supply of materials, supply of plant, all of these matters. So we're heading into very, very much, and the very fact that if there's lots of pricing going on, lots of competition around pricing, means that those prices most likely will be driven down, and driving those prices down in a competitive market when, as I said before, the margins are very tight, and long payment. That is essentially one of the recipes. So if anybody ever looks back at the history of a lot of the different entities, thinking of Carillion, I'm thinking of Amy, and I'm thinking of the Interserve particular cases, that really, when the books are opened and when you look at exactly how the commonality of the factors still persist. So therefore, one of the real key things then becomes, of course, security. How do we actually now securitize a position? I don't necessarily mean the different mechanisms, of course, but if you're lucky enough to get priced for an insolvency bond at this stage. But realistically, the understanding, it's not unusual to see in drafting, and I'm seeing quite a lot in drafting at this moment in time, warranties in respect of the solvency of a particular company and how they actually sit or rest at the time. Ultimately, it's accounts, anybody's different accounts, but we also have, with all of the VAT deferments, all of these different, even the late filing of accounts companies has, it creates that nearly curtain or obscurity that not everything is completely very, very transparent to see the full health of an entity, of how that actually exists. So these are going to become very much testing points, due diligence to understand exactly what the state of affairs. Now, of course, the real risk in all of this, of course, is that when we actually have such a combined hybrid of a system in construction, like we do, talking about from the funds of our beneficiaries to the employers, contractors, subcontractors, even subs. This becomes a very interdependent relationship between all the different parties. That is inherently all across linked. One sneezes, does everybody else get a cold? So there is a lot of instances. Payment provisions become very, very much the order of the day. And the warning signs must always be there. So one suggestion would be, if there was ever a good reason to delay calling out a payment before, and certainly I can't think of too many reasons why one would wait longer, but whatever reasons there were before, they simply diminish and fall away now. We are generally seeing a spike actually in payment disputes, but traditionally, even though it's been addressed in the 2018 Court of Appeal case in Grove versus S&T, that, you know, in terms of seeking the true value of an interim certificate, once if the first adjudication is run on the basis that there has been no payment payless notice, colloquially known as a smash and grab, that you can re-adjudicate on the true value of that account. One particular instance that we are seeing, of course, is that there's quite a number of adjudications being run on the basis that there is no payment or payless notice. And that's given a clear indication that a lot of the market, or a lot of the different companies, subcontractors, are now saying, well, we're not interested in too much in debating the merit right now, okay, but there is no payment payless notice. Procedurally, we are going to actually exercise that prevalence there really is getting that indication that people are suggesting we want to exercise our rights and as money as quickly as possible. So that's certainly one point that really has become forward on that. And of course, then you're into long, lengthy battles in that respect. There's numerous different instances. This is a market now that's quite nervous in terms of the solvency of different companies and who they're actually in contract with. That's very, very prevalent at this moment in time. So moving on then to where, staying with adjudications, which is the recent Supreme Court case in Bresco versus Lonsdale. And this is a case that has been going on for a number of years. It's reached its pinnacle in Supreme Court, as some do. It originally started off with an injunction, and the injunction really was put forward on the basis that to prevent the adjudication from the referring party continuing on the basis that the referring party was insolvent. And this created real conflict, this created a real issue. The ultimate, going back a number of years, the original issue was, did the Construction Act or the provisions of the Construction Act conflict with the insolvency rules in 2016 insolvency rules, in particular Rule 14.25, and that related to set off and liquidated sums and the ability to do so. And it ran its course, a Court of Appeal, of course, and then to the Supreme Court. So there were some various messages that was brought forward during that time, and one was, well, the enforceability of the actual adjudicator's award in any event. So how would that be treated? But ultimately, what's really become pretty interesting from the Supreme Court was its views on adjudication, and that's pretty much what I want to concentrate on now. So ultimately, the appeal was allowed, so therefore an insolvent party can refer and use adjudication. That's the simple the answer on that. So expecting a huge spawning of adjudications in the future of parties who are. And this really assists insolvency practitioners on the basis that the costs, and they have a duty, of course, not to overexpend or certainly to account for those in order to retrieve as much funds in for the benefit of creditors as a whole. So certainly we're expecting quite a lot. And so if you have been certainly in contract, or if you have had relationships with a party that has become insolvent, one must actually be very, very aware of that. Of course, the limited cases, but treatment of Medicide was another case as well that brought out those limited exceptions. But what's really interesting from the Supreme Court was its treatment of adjudication. It really was, it really could potentially open up the whole understanding back to a statutory basis. Minding, or parties can always resolve themselves, later on in the court. And that was always, it wasn't the final position. It wasn't there. So that's the reason why I say, for example, smashing grabs or any of those instances, the parties were not denied their full rights because they could always maintain an action thereafter. And that was one of the various points that was raised. Supreme Court went a little bit further. They were actually deciding, say, well, as a dispute resolution mechanism, adjudication has proved its point essentially, and it's done quite well in respect of being most disputes that go through adjudication, which is abundantly true, is that they are final resort. Parties accept those decisions. They don't really generally litigate through Part 7 proceedings thereafter in the majority of cases. Certainly may have to enforce on those decisions, but in general, it usually is the end. And if the questions are narrow enough in that respect, so it's added quite a bit more credence to adjudications as a form of dispute resolution. But with that, there should always be that sort of case of warning. It's very, very easy, in terms to enter into adjudication and the consequences of such as well. And the type of disputes, I will always maintain, and I say this as being a civil engineer before becoming a solicitor as well, the nature and technicality and ultimately the disputes that would be referred to adjudication it becomes really important. Typically what would be suitable to adjudications before, we've seen such an expansion over the last number of years to really intricate, detailed technical points. And that would, especially when we're talking about mechanical and electrical, and even as a civil engineer, I would not profess to have such good knowledge as a lot of my colleagues who are mechanical engineers. It's a desperately detailed, very, very detailed area, and it's not one to be tread lightly upon. It's anything in MEP at all. But we are seeing very detailed disputes, and getting the right adjudicator becomes inherently important as well. So if there are those technicalities, it's very much worthwhile to understand which adjudicator has those backgrounds. And there's numerous different adjudicators who do have very well qualified backgrounds, and it's worthwhile to examine those. There are some with very good architectural backgrounds and some very, very good QS backgrounds, as well as being very good in law. But essentially, the ability as well for parties to run through at a very, very early stage with adjudication needs very good understanding. on that point as well. So now we're into preparation of that. And this leads now back to onto the next point, and back to the COVID in that respect, because we've all gone through and we've all seen the nature of how force majeure has been. Those parties or people who didn't recognize or understand what force majeure was before, there's no doubt they understand now. They understand what it is. They understand perhaps it's not the actual the bait in terms of time or money, but force majeure, is it an express term? Is it it's not a term of English law, it's a French term. We've described all of these. Now that we've actually moved on, it seems such a long time ago that we're discussing those elements. We've now moved from post-lockdown into a completely different environment. What we're actually looking towards now is that, and what really is becoming apparent, is how parties are preparing and recording and understanding what's actually changed. All this has done is, this has exemplified the issues that were abundantly inherent within the construction industry anyway. And they certainly, it becomes more entrenched. So difficulties that arise about what the common intention of the parties at the time of contract, if we can't establish that properly, we will struggle in the formation of the baselines. So if we describe, for example, some of the difficulties that most parties would have had pre-COVID, but are now translation become very exemplified in this, is the understanding that if a dispute occurs, and the natural reasoning of how that dispute is resolved is, the starting point is, what did the parties intend at the time of contract? Ordinarily, that will become to a point of what is expressly incorporated and what is the contract form. But ultimately, how do we record that? How do we establish that? And this becomes really notified in the difficulty that parties really do struggle with this. So setting out two elements, one being time and the other being money, of course. Money, to some extent, we can understand by suggesting that we have a CSA, or we'll have a
Apologies, we appear to have lost Henry briefly there. Looks like his internet connection has dropped out. I'm currently communicating with him, asking him to poke it with a stick, please, and hopefully we'll have him. There he is, coming back. We lost you there, Henry.
Right, okay, I didn't.
You're back in the room.
Okay, sorry about that, apologies. So just to, I'll go back one or two steps there, where I was describing that the difficulties that has always been inherent within proving a claim, proving the basis of a claim, have really become exemplified now. The difficulties that parties have when establishing during normal times, if I can say that, or pre-COVID times, about the establishment of a right has always been an issue. It's become really much more of an issue now. We're facing into a period of time where we have disruption, that most projects, if not relatively all, have really suffered in terms of how time and money are treated, what provisions under the contract, and how essentially it's established. Like we've talked about obviously throughout about adjudication, but we're now describing how do we prepare for that. And when I say prepare for an adjudication, ultimately one should be expecting to prepare their evidence in such detail so as to avoid disputes in any event. The intention really is to be so persuasive about your information and so persuasive about your case and establish it correctly to the eventuality that you can actually demonstrate it to such a degree of sufficiency without having to resort to a dispute. That must be the case, and that must be the aim, and certainly of every company, not to enter into a dispute at all. But to do that, and especially during these times, really will the quality of the evidence based upon the establishment of that right. So we're into contract risk now, and before I got cut off, I was describing about the common intention of the parties at the time of contract. We've always found that most in the industry struggle with this point, because every dispute is measured against that. What did the parties intend, and if so, for how much? And that's the clarity of these, and that's what really becomes really clear, especially when a case is put together rather poorly. So when we talk about baselines, we now must start thinking about what were our baselines. If we're talking about the CSA, if we're talking about a lump sum or remeasurement, how in fact have we actually described and how are they contained, what we're measuring towards. The difficulty, of course, arises when we look at something of a former contract like the NEC or JCT, which are the two most abundantly covered. If we describe that the NEC is heavily dependent, of course, on, well, the works information, as it's in terms of, without going too much into new terms, but say the works information, or indeed if we look at the JCT, which is the employer's requirements, there are no real set out prescribed methods or ways to actually compile the documents. And of course, then it becomes very much subject to the actual interpretation of, especially if we're talking about hierarchies. But because there is nothing set out, and there's a very good reason why, because if they become overly prescriptive, then they become even more difficult sometimes to follow if they're not prescriptively followed as well. So they're left quite open. So in any key thing that we've always suggested that nearly all, if not most, of the disputes have always actually occurred at the time of contract formation. And that might appear quite a strange comment, but most of the disputes can be traced back to the point of time of formation of the contract, and in fact the ambiguities that rest, or the risk allocation, because events have occurred that ordinarily would not have been foreseen, either reasonably or unreasonably foreseen at the time. But however, those events have occurred. This is a perfect example now. Most contracts before, especially towards the turn of the year from 2019 to 20, many would not have perceived that COVID-19 would be an issue of that. So to measure against what is in relation to time or money, we are now talking about issues we have left behind the force majeure or the aspect, because that was a certain time in relation to lockdown. Force majeure was one element that would give time but not cost. So how are we now affecting the position of a disruption? Who takes responsibility for that? If we look at the whole risk allocation in terms of licenses of a construction contract, contractor takes responsibility for carrying out the works. And unless there's an excusable reason that's followed through by a relevant event or a relevant matter, then we are now in the difficult position where they may have to accept all of those risks. We start getting into very strange, difficult arguments, because if we have a system of subcontractors and each of the different subcontractors are interrelating with each other, and if they're all interrelating, but one is affected by their own social distancing or their own inability, and that in turn affects numerous different subcontractors, does that give the other subcontractors the right then to actually make a claim against the main contractor? And ultimately, we now get into a system of subclaims upon that causal effect. Now, to generate out those claims, the key point that very few people seem to be really putting their focus on is causation. And causation is a legal term, and it identifies the direct cause and effect between the breach and what the actual result are, occasioning losses, for example. And that becomes very much, but it's that causation can't be broken, but what is the breach? And what we're seeing in a lot of different instances now is that parties are not attaching their minds. Everybody recognizes that the disruption has occurred. Everybody recognizes, of course, that each and every one of these events have actually produced very much a detrimental way of working. But what is the breach? So if we can't attach ourselves to the breach, and if there is no breach, inherently it might be the contractor or the party that accepts the risk on that potentially. So now we're opening out into cross claims, and this is one of the different elements. When this all occurred, one of the very first indications for many of the clients was to actually start seeking agreements at very early on stage. So as the contracts are starting to develop out and come towards, we're now seeing a quite significant uplift in valuation disputes or loss and expense disputes, disruption. And disruption has always been perhaps one of those most difficult routes in terms of causation. Global claims, all of those different points have always been particularly difficult. However, it does not change the actual basis which a party must prove. The ultimate point as well is this will all need to be underpinned by the necessary evidence. It'll all need to be, and how the evidence is actually presented. So this is a time that if parties are seeking disruption, that they start following. First of all, we establish a right. We establish a right under a relevant event or a relevant matter. We actually bite into one of the known reasons. Of course, we have the catch-all clauses, and that includes with NEC as well, also. Once we have the point of view of liability established, or that we can occasion that breach or if there's responsibility, we now turn to the quantum being made up of time and money, and now how those losses are actually established. This is very much a procedural step forward, but well laid out, and determinative claims is especially important now, like no disruption. So if we describe a course, if we get one instance of social distancing, how does a party prove that they would have done such work much quicker, shorter space of time, for less money, less resource, and that was their intention at the time of contract. And if they can bite in with the liability, that's another party's responsibility, how do they prove the difference or the net effect between the two? And that's not entirely an easy prospect. It requires that there has to be a reasonable degree of proof as to what your original intent was. Now, proving what your original intent is a matter of fact and degree and information at the time. Most parties really have struggled with describing what their baseline programs are, as opposed to even establishing what their as-built is. But certainly, to get the differences between the two becomes an inherently difficult project in itself. So record keeping, and then we have data, because this is an industry that is complete with data. There's quite a lot of different elements of data, but it's the quality and it's the arrangement of those data pieces that shifts to the point of getting over the burden of proof with reasonable, the bounds of probabilities that more likely than not that these events did occur, and to what degree. So that is the issues that we find. And that's the issues that we see very much in coaching with those as well. So essentially, we then move on to where the future, and in one of the last instances now, that what the future actually is going to persist in this respect. Beforehand, there might be an excusable position to say, well, COVID-19, of course, was an unforeseeable event, and most parties will try and suggest that. Again, there will be probably judicial authority in that in time to come. There's no doubt about, and surrounding the rules around force majeure. But what really becomes very clear is that it had to be unforeseeable at the time of the contract. If we get a second wave, or these disruptions continue, or indeed for the foreseeable future as to how parties are to interact, one of the real chief things that is really evident is it's foreseeable. So those parties entering into contract now are certainly those who are tendering. This becomes a very, very key point to what extent. And I don't in any way envy estimators. Estimating is a term of art that's difficult enough in the best of times, let alone during times of uncertainty. But we are now deemed to have seen that what is foreseeable and what's unforeseeable. So this becomes very important in terms of expected drop. And it's not just clauses relating to force majeure or pandemic as well. So we're talking about disruption, we're talking about the interrelationship between parties, we're also talking about payment. All of these different aspects as well. We're talking about retention of title clauses, of course, as well, of how parties will, if there is a risk of insolvency in these elements. So the full engagement going into future contracts is now really a hot topic. We've certainly seen very much an emphasis on what it is without having a crystal ball, but using the rules as they exist, contractual provisions as they exist, the foreseeability points, and then to de-risk those elements as much as possible. And that's not always the easiest point in this market, because it's become a very competitive market where numerous parties are in fact now actually competing against each other in a contracting market as it stands, reduced pricing, and therefore the propensity towards more risk actually invariably interjects and comes into play in that case as well. Okay, well, I'll leave it there now this evening, and thanks very much. And I just see that there's a couple of questions at the moment, and I'll just take for the point. Project manager instruction, the contractor to restart work on site under clause 34.1 NEC option B. Is this instruction a compensation event? If so, under which event, please? Okay, so there's been a lot of debate in terms of different contracts about whether or not how parties actually can, what clauses they can bite into. And some very far-flung different elements have been raised. Was there a change in law, for example? JCT, after the base date, that's unlikely to succeed in that respect with JCT of that element. The real reason here is because, like, you know, what is the actual law? So that we don't see anything that have a bit in with the Coronavirus Act guidance, or like we had 4 stages of advice at different points as well. Nothing overly mandatory by the government at the time as well. So those arguments really could struggle in that respect. But this is different. This question is a little bit different. What we have here is that the project manager actually has provided instruction. And I think if I refer actually, yeah, it's actually clause 60.1 sub 4. And I just have it on the screen, which I can read actually. But it's the project manager gives an instruction to stop or start, not start any work. And actually that's one that has been raised, because once the instruction is provided for, that will bite in. So if the project manager has done so and given that instruction, then most likely I would expect a party to be pursuing that under that compensation event as well. Okay, Julie, I'll hand it back to you. Thanks very much.
Okay, thank you very much, Henry, for your time. Thank you everyone for attending, and we hope to see you again soon. Stay safe in the meantime. If anyone has any specific queries about any of the things that Henry's been discussing tonight, don't hesitate to contact him directly on Henry Hathaway at silverllp.com, or you can come in via the seminars and I will forward it on to Henry. So thank you for joining. Stay safe everyone, and we will see you again soon. Thank you, Henry.